Guys, here's a new thought. I think what we'll do is we'll pause for our formal introduction when the dean arrives, but we'll actually kick things off now since we're all here. We're all kind of locked and loaded, and we're poised to have a fantastic conversation with Bob Bauer and Kathy Ruemmler, two recent White House counsels to President Obama, who will talk to us about the office of White House counsel and how it interacts with issues of law and policy and politics. These two folks, Bob and Kathy, are really consummate White House counsels and consummate professionals whose careers have brought together political life and policy and law practice really at the very highest levels. Bob is a renowned expert on the law of politics, which is to say the law of campaign finance, redistricting, regulation of congressional ethics, tax-exempt advocacy issues, and of course recounts. He came to the White House counsel having previously served as general counsel to President Obama's 2008 campaign, a role that he then reprised in 2012 when he again served as general counsel of the campaign. In 2013, after his service in the White House counsel, President Obama named Bob to be co-chair of the Presidential Commission on Election Administration. I can go on and on. This is a tremendously illustrious professional who's sitting to my left, another one sitting to my right. Bob has written and co-authored numerous bipartisan reports. I just want to call attention to one because it came relatively early in Bob's career, I believe when you were 35 years old, namely a report on the presidential election process in the Philippines. And so kind of a taste of the eclectic and global outlook of the massively accomplished lawyer-statesman sitting to my left. The massively accomplished lawyer-stateswoman sitting to my right, Kathy Ruemmler, has split her time a little bit more evenly than Bob, who's devoted most of his life to private practice, between public and private practice. She is widely regarded, and I guess in a good way, feared as a hugely accomplished leader of the white-collar criminal bar. It's good to be feared in that position. Maybe it's good to be feared as the White House counsel, something that we could talk about as well. She served as White House counsel, succeeding Bob from June 2011 to 2014. And in fact, during Bob's service as White House counsel, Kathy was Bob's deputy. So the two of them have worked collaboratively together, and each of them has also led that office. Prior to coming to the White House, she served as Principal Associate Deputy Attorney General at DOJ. And prior to that, Kathy tried more than 20 cases to verdict, both inside the government and in private practice. She worked for 6 years as a federal prosecutor, first as an AUSA in Washington, D.C., and then later as the deputy director of the Enron task force, where in 2006, also at the mystically important age of 35, she delivered the government's closing argument in the trial of former Enron executives Ken Lay and Jeff Skilling. So just a little bit of a taste of who we're talking to this evening and why it's so important to get their perspective on the practice of law inside the White House, which is the subject of our Guarini lecture this evening. I'm going to begin with some questions, but feel on the hook for participating in this conversation. It's coming up to, about 10 after or so. At around 20 of, we'll pivot from conversation on the dais here to conversation that's much more interactive. So please begin to collect your thoughts in that direction, and don't be sheepish when we actually get to that moment. So let me begin by asking both Bob and Kathy, I don't know which one of you won the coin toss before the game began, but let's ask both of you a core question about the identity of the White House counsel. So many of us in this room have studied opinions of the Office of Legal Counsel in the Department of Justice and are aware, of course, that the Attorney General functions as the head of the Department of Justice. So let's talk a little bit about who the White House counsel is as an institutional matter. Who is the client of the White House counsel? And if I could also ask you, since you both serve the same client, the same president, tell us a little bit about who your client was as President Obama and what it was like to advise someone with the honed legal chops that the president possesses to be his lawyer.
You can see how our dynamic worked as he just tells me what to do and I do it. So it's a great question. It's actually a more complicated question than at first blush it might appear to be. I think that that in general, the answer that most White House counsels would give, including myself, is that the client is the office of the President of the United States, and that you are certainly representing the particular occupant of that office. But it's a very different relationship than the kind of relationship that you have, and I'm sure that you all have talked about in your classes, with an individual client with whom you have a very, traditional attorney-client privileged relationship, and who you can advise on his or her, sort of personal legal issues. And one of the things that, as the White House counsel, that you're sort of very frequently thinking about is this question that's presented to me a question that relates to the President in his official capacity, or a question that relates to the President in his personal capacity? And Bob and I, when Bob had gone back to work for the re-election campaign, and I became the White House counsel, and Bob was also and continues to represent the President in his personal capacity, we would have conversations about some questions in which those issues would come up where the line wasn't as clear. And one that comes readily to mind is that when folks would go into particular states and challenge the citizenship of the President, and therefore claim that he, could not be on the ballot, that was one in which we had to discuss, well, is this something that really relates to the office holder, the President of the United States, or is it more in his capacity as a candidate, or in his personal capacity, because what they really are challenging is, his actual birth certificate, frankly. And that was one where it was, we had a lot of conversations with it, including with the Justice Department, about whether in particular circumstances the Justice Department could come in and enter an appearance in that litigation, and actually advocate on behalf of the President. Bob, is there anything where you?
That's right. As a matter of fact, at some point, this became a subject of bizarrely fascination yet again with the national press. We'd already produced a birth certificate for the President in 2007 and posted it online, and then it somehow came back again. And the question was, well, there's another birth certificate and it's in the vault in Hawaii. Why don't you produce that? So we had to produce that, or somebody thought we did. And we wound up arranging for then personal counsel, who took over when I was in the White House and handled the personal representation, to be the one to fly to Hawaii and retrieve that from the vault, I might add, through the normal legal processes available to all citizens in the state of Hawaii. And the reason was that we didn't want to question about why we would have, as government lawyers, been concerned with retrieving a personal identification document for the President, even though when it arrived in the White House, we took it to the White House briefing room and answered questions from the press about the birth certificate. So it's very peculiar, and as that episode shows, there's really no clean way to distinguish these capacities. And I would only add, in addition to the personal and professional or official position the President holds, of course, from 2009 to 2012, at a certain point, both legally and at all times, at least prospectively, the President was a political figure, a candidate for re-election, which is a third capacity, yes, in which he required representation. But it's not something the White House counsel can be completely indifferent to, cannot take into account in functioning in the office.
You know what, folks, I think we're going to interrupt our regularly scheduled program for 1 minute because Dean Morrison is here. And while he's coming up to the podium, I should just say of Dean Morrison what everyone knows, which is not only is he the dean of this law school, but he's also really the country's foremost expert on the practice of constitutional law inside the government. So this is someone who is deeply steeped in the issues we're going to be talking about as well. The dean.
Thanks, Sam. Apologies for being late. Welcome to Bob and to Kathy, which I'm sure Sam has already said. The part about foremost expert is embarrassingly wrong at the best of times, but when there are two ahead of me in the queue here, it's even worse. So I don't want to stop proceedings for long at all, but just to say that it's terrific that we have such a great turnout this evening for a really excellent event. I'm really grateful to Kathy and to Bob for being here. They are great exemplars of public service, rendered with great distinction. They are also great exemplars of the fact that the public and the private sectors aren't nearly so separate from one another as is sometimes imagined. Bob and Kathy have had and are continuing to have wonderful careers in the private sector, in addition to serving very important roles at very important times in our country's history in the public sector. And so just in their persons represent what we hope for in our students, which is not just those who start their careers in public interest or government service, but those who start in the private sector as well, understand that the public service is something that can be pursued, and service to the public is something that can be rendered by all lawyers and certainly all NYU law graduates. So with that introduction that should have come 15 minutes ago, let me stop and return you to the conversation.
Awesome. Thank you. Okay, so it sounds like we've gotten some traction thus far on how to think about the White House counsel in respect to the office of president, vice the rendering of legal services to the president as Barack Obama. Let's now talk about the world of law practice in the White House versus the law practice that goes on in the Office of Legal Counsel that Trevor knows so much about and has written about. So the question now becomes, what's the look and feel of law practice in the White House? Does politics, does a sensitivity to the kind of policy dynamics necessarily shade your legal advice more so than it would, let's say, if you were practicing law in Department of Justice somewhere? Kathy, could I start with you?
Sure. I think that I would characterize it differently than shading. What I would say is that I think properly executed, the role of the White House counsel is to take the legal advice from the Office of Legal Counsel, if you have sought the legal advice from the Office of Legal Counsel, and the hope is that you receive, that the advice that you receive is really, to the extent such a thing exists, sort of pure legal advice. In other words, you don't want, at least I didn't want, and Bob may have a different view on this, but I didn't want the Justice Department and the Office of Legal Counsel to be thinking about the political dynamics around a particular legal question or the policy dynamics around a particular legal question. That really is the job of the White House counsel, to take the legal advice that you're getting from the Office of Legal Counsel and figure out how that legal advice fits in with the political dynamic or the policy dynamics, which are always present for the White House counsel. The White House counsel doesn't have the luxury of sort of disaggregating, if you will, those other factors, because the very position sort of sits at that center of those various factors coming together. And so sometimes you might get legal advice, for example, that was politically impractical. And it's the White House counsel's office job, sometimes in consultation with other members of the president's staff, senior staff, to sort of talk about whether or not the advice is practical, whether or not it can be actualized, whether or not it can be realized. And vice versa, sometimes the political imperative or the political desire or the policy desire is in conflict with the legal advice. And so what you do is you spend a lot of time trying to reconcile these things and to make sure that you sort of have visibility into all aspects of that so that you can give the president harmonized advice, or advice that's not tone deaf to policy imperatives or political imperatives.
Bob, can I follow up with you on that? Sure. Does it follow from what Kathy just said that the OLC lawyer's advice can or often is tone deaf to those sorts of political and policy concerns?
No, I wouldn't say tone deaf. I think Kathy has it exactly right. I think they approach the job with a defined sense of mission. And let me be clear, and I think Kathy is also saying this, but she'll correct me if I'm wrong. I never had a problem with Kathy when I was in the White House correcting me when I was wrong. It's something I could always rely on. And that is, the White House counsel is also engaged in legal analysis, and there's no point at which the legal analysis is, and sound legal analysis is set to the side for political considerations. But like in any business, and Kathy said it very well to my class a couple of weeks ago, I had her in to speak to a class we have in which we talked about this very topic. no lawyer counsels a client intelligently unless the lawyer thoroughly understands the client's business, quote unquote, the industry, the context in which the client is operating. And I think what Kathy has in mind here quite correctly is that the White House counsel has to bring to bear an understanding of the policy and political background in talking about the choice among viable legal alternatives, because typically there are competing views of what legal path to take. And the only other point I would make is when we talk about politics, we're not talking about it, and by the way, this is what makes it so hard, in the coarse sense of pursuing political advantage, like greasing the skids for the re-election effort. We're talking about political pressures in the broadest sense, constituency pressures, that come from constituencies that are committed to the party, political pressures that are generated through allies in the press, political pressures from opposition. They're not political pressures that are self-interested in a narrow sense, but they're just part of the deeply, profoundly political world in which the president operates, and to which the legal advice necessarily should be responsive.
So let me.
Can I just give one example on that? Because I think that's a little abstract, but maybe I can make it a little bit more concrete in a way that's understandable. So if the Congress has passed a massive spending bill, and there are all sorts of different agencies affected by the spending bill, and spending bills don't generally just they are generally about spending, but they also have great policy implications. So Congress might say, well, the Department of Energy cannot spend money on discussing nuclear disarmament with, Iran. That's just hypothetically. That never happened, but just say that hypothetically. I wanted, when I was White House counsel, OLC to go through that spending bill and tell me everything that was potentially a constitutional problem. And so that's what they would do. And they might say, we recommend that the president either issue a veto threat if the bill is just pending, or actually veto the bill because this provision encroaches on the president's constitutional authority to conduct foreign diplomacy. Now, the practical reality and the political reality is the president is not going to veto an omnibus spending bill over one provision that encroaches, even though unconstitutional, which, I very well would likely agree with. But what I wouldn't want to happen is OLC to sort of self-censor and say, you know what, the president politically isn't going to veto a huge spending bill, so therefore I'm not even going to make the recommendation to the White House that the president veto.
But what's the value, though? What's the value of that OLC opinion? I understand they're kind of the geek experts in constitutional law, and it's comforting to know that the geeks have scrubbed the document and have been through it and have identified all potential defects. But if the defect isn't going to lead to any political action whatsoever, what, other than the satisfaction of knowing that they've been through it, what does that document do?
Well, there are a lot of practical things. So if you have the benefit of knowing the provisions, before it's sort of too late to object, you can issue an OMB statement of administration policy is what they're called, or SAP, or that basically says, this is a problematic provision. You can talk on the staff level to congressional staff and say, we understand what you're trying to do here, but the way you've done it is actually presents constitutional problems. Or, and what happened very frequently, is that the president, would issue a signing statement, which is controversial in and of itself, but a signing statement saying, I'm signing this bill because I need to sign the bill in order that the government keeps functioning, but there are these problematic provisions, and some of them are unconstitutional, and I'm going to state my constitutional objection. But if you put OLC in the position where they're trying to do that thinking for you, which really is not their job, then you have people who are, again, it's not their responsibility, but potentially making sort of political judgments that the president wouldn't necessarily agree with. And he, of course, isn't talking to them. He's talking to me, or he's talking to Bob. He's talking to the White House counsel. So I always felt that it was very important to make sure that OLC was able to do its work in a way that was sort of protected from those other considerations.
And by the way, this sets up a bit of it is unavoidable. It sets up the usual sort of conflict that is seized on by people on the outside, right, Kathy?
Yeah,
where they
absolutely.
say, oh, OLC gives legal advice and the White House counsel is a collection of political hacks, right? So it can be cartooned, if you will. It can be caricatured as, good legal advice comes to the White House and gets butchered by political operatives, which is, like so many other kinds of depictions in the Washington political space, extremely misleading. But I think Kathy absolutely correctly describes what the roles are.
Let me try my hand at caricature. Is that okay?
Fire away.
So here's a key moment, or certainly a moment that the media picked up on, Bob, in your tenure as White House counsel. We talked about it in my LRS class this morning. A moment where the OLC had recommended that the president's conduct of military action in Libya qualified as hostilities for purposes of a statute called the War Powers Resolution. But you concluded, your office concluded, alongside the legal advisor in the State Department's office, that in fact the definition of hostilities was not met, in which case there was no obligation upon the president to inform the Congress or to seek approval of the Congress for the operations in Libya. So
For the continuation.
For the continuation of the operations in Libya. So was that a good example? Can you give us a little bit more perspective, riffing on that example of how OLC, which in the kind of ordinary, I would say stylized thinking of law students and maybe legal academics, would have been the place to corral different points of view, the opinion of the Department of Defense, the opinion of the Department of State, but somehow here the OLC became just one view among many, ultimately a loser vis-a-vis your view?
A couple of points there. And by the way, Kathy's should also be invited to. She was there, and so she recalls this debate, I'm sure, very vividly. First of all, it's important to remember that at the head of OLC is an assistant attorney general and acts in place of the attorney general in rendering this kind of advice. But at the very end of the day, though it doesn't happen every day of the week by any means, at the very end of the day, there are judgments that are made by the President of the United States, and those are his judgments to make. The White House counsel helps the president understand what differences among the agencies are. What is critically important is that the process by which those judgments are elicited is an open process in which there is ample discussion with all components of the government. And so, as you pointed out, there were views at DOD, there were views in some of the other component agencies, views at OLC. On a question that actually, in a number of respects, was fairly difficult. Some people would like to portray it as not difficult, but in a variety of respects, I won't bog you down with the details, I think it was more difficult than it was sometimes portrayed to be. The OLC's views were heard, as were the views of the other component agencies. And as you point out, at the end of the day, the end of the process, the State Department legal advisor and the White House counsel were in one place. Lawyers elsewhere in the administration were in a different place, and the decision the president made was to adopt for those present purposes the position that the White House counsel and the State Department legal advisor had put forward. That is not to say that the wrong legal conclusion was arrived at. It is to say that a different legal conclusion was arrived at on a very difficult question that ultimately the president had to answer for, and the president did answer for it. It was known publicly that that was the position. Congress was aware that it was a position. Congress was in a position to respond should the Congress have chosen to do so, and did not do so. As a matter of fact, the House of Representatives put itself on record with two resolutions that were diametrically opposed to each other. And that's just part of what sometimes happens in a complicated set of circumstances. And what I want to do is distinguish that case from one that really troubles people, and I think it troubles them correctly, which is when the decision-making process by which these legal views are elicited occurs within a closed space. And there actually isn't an opportunity for the component agencies to express their views, and those views are not weighed in the process. That was not the case leading up to the Libya decision.
Kathy, I know that you have vast experience with the Affordable Care Act. There's a famous photograph of the president embracing you after you've informed him and his chief of staff, Jack Lew, that he won in the Supreme Court in the I would say, the first challenge to the Affordable Care Act.
Right.
It's like the Gulf War. We're going to have to call it the first Gulf War, the
big
first
one,
challenge.
the big
yeah.
challenge.
Yeah. With the next challenge, still, I guess, up in the air. But I know that you also had a lot of experience thinking about the legal and the political implications of the regulation of contraception that accompanied the Affordable Care Act. So I wonder if you could share a little bit about that experience.
Yes, and I think that was, that still continues to get litigated in the courts, and I think is the subject of a lot of debate. And the question there with respect to the contraception rule, the rule, I think, as many of the people in the room are aware, it mandates that certain employers, if they choose to provide health insurance to their employees, that they have to provide contraceptive coverage as part of that health insurance with no copay. That's essentially what the rule says. And so that seems pretty straightforward. But what wasn't straightforward was that a number of employers that were religious employers objected to the idea of as part of their health insurance coverage to their employees, providing contraceptive coverage as being, sort of anathema to their religious beliefs. And so with respect to a certain group of employers, that seemed like a pretty straightforward way to kind of solve that problem. So churches, houses of worship, where the employees were engaged basically in religious ministry, and you had kind of a group of, unified religious people. They were employees, and the church was an employer, but it's a church. And so the draft, the rule said that if you are a church and an employer and you provide health insurance, then you are completely exempt from this rule. You don't have to provide contraception. But there was a harder case of employers, and those were sort of roughly defined as Catholic hospitals and Catholic charities. So, and some Catholic institutions like Georgetown or Notre Dame, where they are, deeply religiously affiliated, but there are all sorts of employees at these, basically at these institutions or businesses or in charities who don't share the same religious beliefs with the employer. So the people who wanted a very broad rule were going to, the administration and saying, well, why should a nurse who works at a Catholic hospital in Chicago, who is Methodist, have to be denied something that every other employee in the country is getting because she happens to work for a Catholic hospital? And the Catholic Conference of Bishops would come to the administration and say, well, you have to understand that this is really part of the deep faith of these institutions, and it's really hostile to our religion. So there was an enormous amount of internal deliberations among the lawyers to sort of how to strike this balance correctly. And it was a great example of the kinds of legal issues, and Libya is another one, where there isn't a right answer. There isn't a right answer that is knowable, because you can't look to a Supreme Court case that's on point, or you can't look to a particular statute, and everyone's sort of trying to make their best judgment about how to strike this balance correctly as a legal matter, as a policy matter, and as a political matter. And so when the rule was first announced, there was massive outcry from the sort of organized Catholic community, really, really, severe criticism of the rule as it being kind of anti-religion. And at the same time, Planned Parenthood and a lot of the women's groups were going to the administration and saying, don't you dare cave to the pressure from the bishops, So there was this just confluence of things. We ended up actually redoing the rule, recalibrating the rule to allow for sort of, different levels of exemptions. But what's interesting about that, I think no one anticipated to the degree in which it has gotten traction in the courts, is that private employers who are just, the rule just applies to them. right? And the Hobby Lobby is the classic example. That's a big box craft store that employs thousands of people all over the country, and the people don't have to be of a particular religion to be employed. And so, the administration's view was you are just covered by the rule. You have to provide contraceptive coverage. And I think the fact that that has gotten as much traction in the courts with private employers was meaning that they would go in and say, this violates, we're a private employer and our religious freedom is being violated, was, I think, a surprise to many of us who worked on the rule. But it just goes to show that you're making your best judgment, and you don't really know kind of how things will ultimately unfold in the courts. And the courts are not immune to their own sort of predilections and feelings and views about the correct balance on religious liberty versus the right to free contraception.
Let's talk a little bit, it gives a good sense, Libya, contraception, Hobby Lobby, this gives a good sense, I think, to all of us of just how weighty and complex and how politically and legally fraught these issues are. Tell us a little bit, if you would, about the president as a client, as a recipient of advice. So the president, I gather, is not getting memos from you, or maybe he is.
President does get memos.
And so the
Yeah.
question I have is, in addition to getting memos, are you also having one-on-one sidebars with the president where you're saying, in effect, okay, here's the deal, and what's the music of those conversations, such as you're able to share it without violating the attorney-client privilege?
The music depends entirely on how much he likes the advice.
It's true.
Yes, it could be
You get the skunk eye, it could be an abbreviated
yes,
conversation.
Exactly. Light and lively or funereal.
Yes.
So what's it like to say yes to the president? What's it like to say no to the president?
Well, I'm being facetious. I mean, the president wasn't punitive toward lawyers telling him, complicated or distressing things. But the role of the lawyer in the White House under this president has been, very much to the advantage of the attorney in this very critical respect. That is, that there are certain things about the explanation of a particular set of legal alternatives or a development in the law that don't have to be belabored. So, for example, one of my favorite examples is that if we were having a conversation about Supreme Court ruling and the question of the standard of review came up, the president didn't have to be told what the difference was between strict and heightened scrutiny or rational basis scrutiny.
Yeah.
I mean, the president knew that perfectly well and had taught it. And so that's a tremendous advantage because it means that, you're having a conversation in which there's certain sort of core doctrinal understandings that are shared between the lawyer and the client. That's I think, a tremendous advantage. It also, by the way, and I think Kathy would agree with me, it shaped the liberty with which we could write our memoranda. We never had to write them down.
Yes.
You could write the memorandum to the president as you would write the memorandum to a senior partner at a law firm. You wouldn't want it to, you weren't delivering 56 pages with 700 footnotes because the president had other things to do. But you could write a memorandum knowing that you were addressing a very sophisticated, experienced consumer of legal analysis.
Would he mark up the document?
Questions in the margins, yeah, absolutely would mark up the document and put questions in the margins. And it might be a very specific question to which the answer could be delivered in a subsequent writing, or it could be a question that would be then taken up in the senior advisors meeting. We'd have senior advisors meetings. By the way, lawyers typically went first in the senior advisors meeting, which was an interesting development. The lawyers were called on first, not by the way that we were expected to hold the floor for 2 hours, but we did go first. And then one might say to the president, on Memo X that we sent in to you, you had a question, why? Here's the answer. Here's the information you wanted. Here's the further clarification that you were looking for. So I think that's correct. The one thing to keep in mind is that the president is still the president, and the president is still the client. So while the president was a sophisticated consumer of legal services, I think it's fair to say the president wasn't in the business of, how would you call it? It wasn't another lawyer in the room. Right? The president was actually looking for legal advice and not looking to sort of argue about what that advice ought to be.
Right, I think that's right. And, with one thing that you can't do as a lawyer, to the president, or frankly, I think probably to any repeat client, is you can't be, sort of the little girl who cried wolf, which means that you're kind of, very concerned about everything the president wants to do, and you're saying no, 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 no all the time. If you do that, then the president, I think certainly this president, but I think any president will tune you out. And certainly the other members of the senior staff, all of whom are also your clients by extension, by the way. And so, I think the key is to make sure that you calibrate, and so that when you really say, absolutely not, or Mr. President, I have very, very serious concerns about this, and I strongly recommend that you do not take this action, or you use sort of language like that, that's a pretty rare thing. And that when you say that, people are like, oh, I used to say, like, if I threw a flag on the play, then generally people would be like, okay, whoa, well, And it's because I think I had earned enough credibility over time with the president and with other members of the team that I would work with them to try to accomplish their objectives and help them do it in a legally sustainable way, such that if I really was, drawing a hard line in the sand, it was because it was something of significant concern.
Yeah, and if I could just add, and the trick is, and those who were, I see a couple of them here who take the class in which we've talked about this that Kathy attended the other day, the trick is to navigate between being too much of a lawyer and being too little a lawyer.
Yes.
Too much of a lawyer is the one who's continuously displaying erudition and a certain sort of intellectual obstructionism. No, oh, that's terrible. Oh my God, I don't know. Geez, that could be a real problem, And then everybody's annoyed because it's not terribly constructive. It's almost exhibitionistic. I'm the lawyer in the room, and I'm going to continually remind everybody that I'm sort of a heavy professional presence that everybody has to pay attention to. Too little of a lawyer is the one who cannot resist, in the guise of giving legal advice, pushing into the political and communications conversation. Oh, I don't think that's going to go over well on Fox News, which, by the way, was very few things that we did went over well on Fox News. So that was not exactly a telling criticism.
Killing bin Laden went over well on Fox News.
Yeah.
For 2 days. Yeah, exactly. So I don't know if that's going to work, and that's going to really upset, our target demographic. I mean, the youth vote will be affected by. That would be deadly, because then the question is, who are you? Are you the lawyer, or are you the political consultant here? And so finding that, as Kathy said, that lane where you're being a lawyer at all times, and to the extent that you're throwing down a heavy legal marker, it will be respected because you don't do it reflexively or for display. Or when you're bringing political considerations in, you're bringing them solely in the service of the best possible legal advice that you can give.
And that's true on policy too,
Yes.
and the contraception rule is a great example of that, because everybody on the senior team in the West Wing had very strong views on what the right policy should be. And it was probably the most contentious policy issue that I had seen, in terms of people, like, there were a group of people who just were adamant that we should exempt the Catholic charities, and there were a group of people who were like, absolutely not. And they would go to the president and they would, advocate these views and strongly advocate, and they would come to me, and this is not atypical, but people who are advocating a particular policy perspective, they would come to the lawyer and they try to get you to put your thumb on the scale legally. Well, isn't it true that we would have we'd be more likely to defend this in court if, the rule exempted the Catholic charities and the Catholic churches, and they try to get you to sort of push it and get, it's like Survivor. Everyone's trying to get like allies in there. And you have to maintain, the president has to believe at all times that when you are giving your best legal judgment about things like litigation risk or something, that you're not bringing your own policy views to the table, or that you haven't been co-opted by one of the other groups. And this president's very shrewd on picking up on that. And I actually remember one time on that issue in particular, he called me into the Oval Office separately, and he said, I need you, I want you to look at this particular issue that related to it, and I don't want you to tell anybody about it, because frankly, I don't trust that anyone else is giving me straight advice. They're giving me their own kind of, what their outcome-driven advice. And so that's really key too. And I think if you lose that, and the president just starts to think of you as one other of those players who are kind of trying to get stuff done and push stuff through, then you really lose a lot of your authority and your power in the position.
And if I could, that's absolutely right. And one thing I want to stress is, it is amazing the extent to which non-lawyers suddenly have a license in hand that adequately serves the position that they want to have taken. And it's very difficult to be in meetings where lawyers deliver what is reasoned legal advice, and somebody relatively significant in the building says, oh, that's just ridiculous. That can't be right. I mean, that just can't be right. And they can shop. They can shop for contrary points of view and then throw it in your face and say, well, I talked to so-and-so and he said that can't be true. And, one of the prerequisites for maintaining the client's confidence is not to melt to the floor in those circumstances. You have to be able to say, well, I'm really glad that you have your own independent avenue of legal advice and analysis based on your 0 years in law school and practice. But that's the view that my office takes, and the reasons have been laid out for you, and it's really up to the president, ultimately, to decide, what credit or otherwise he gives that particular line of reasoning.
I'm going to turn to all of you in a moment. I just wanted to ask the two of you one last question. It has to do with transparency. So there's obviously been a big push to have OLC memos be matters of public record so that we can all look at them, we could all take stock of them, criticize them, and kind of recognize their significance in shaping policy. Do you believe that that's right in the case of OLC memos, and does that commit you to a particular view about the transparency, at some point anyway, of the memos that you wrote to the president in your White House counsel role?
I don't think it commits you. I don't think there's a principle that you would adopt or a position you would adopt on OLC that necessarily requires you to arrive in the same place for the advice you give the president in the White House counsel's office, because the relationship is different, and the consequences of publication are different, and the public interest in seeing the advice that you've given is different. But as a general rule, I tend to agree that I'd be interested, I think Kathy and I have discussed this, but I don't entirely remember whether we're totally in agreement on this, but I think that the OLC benefits where it is possible within articulated, principled standards. It is benefited by publishing opinions. It cannot publish all opinions, and it cannot publish all parts of all opinions, and there are very good reasons why it cannot. But to the extent that an administration appears to be pushing in the direction of publication as a first instinct, as you will, as a first principle, I think that is better than the contrary point of view. And I think, quite frankly, in the past, it has not served OLC well to operate in the shadows where it could have brought the light in on particular legal processes and outcomes.
I generally agree with that, with the following caveat. I think that not every OLC opinion should be published or needs to be published. I think that the principles that OLC has established for publication are actually good ones. What I fear, if we move to a place where all OLC opinions are either provided to Congress or to made public, the result of that will be a smaller and smaller number of published OLC opinions. And I think that is bad for the institution. I think if you look statistically at the number of formal OLC opinions, which are the only ones that are really being discussed as possibly being published, or formal opinions, the number of requests for formal opinions from executive branch agencies to OLC has declined precipitously over the past decade, and I think that's in large part because people know that that the dynamic changes if the advice is sort of for public consumption. It changes the nature of it. And what you also see, it's a very, very sad thing that has just happened, this is sort of part of just the political environment, is that if the leader of the office is asked to give legal advice on a subject that is politically divisive or unpopular, it can have really profound impacts on their future career. And then what you see is you see people, this happens in the government all the time, people trying to avoid being the person whose name is on the line for giving the advice, even if it's absolutely correct. And I think that also is a really unfortunate, consequence of it. So, and I also think that if you start to say, well, all formal opinions are going to be released without respect to following kind of whether or not there's a significant public interest or a significant constitutional issue at stake, then you're very soon going to be into the world of, well, why not informal opinions? And why not informal advice? And why isn't that all subject to congressional oversight? And then you've just really fundamentally changed the nature of the attorney-client relationship between OLC and not just the president, because the vast, consumers of OLC's advice are not the White House, but the CIA, DOD, EPA, HHS, the rest of the executive branch. And I think what will happen in that scenario is that people will be less likely to go to OLC because they don't want even to know, they don't want to have to deal with the fact that they've asked a question and maybe gotten advice that they couldn't do something. It just changes the very nature of it. So I think confidentiality has some real value in this context.
Your questions. Yes, please.
This is a question mainly for Bob. So the U.S. and its allies began sustained airstrikes against ISIS refineries yesterday. And as an international relations major, I'm just very interested in how you decide the lines or criteria for assessing whether such military actions qualify as hostilities covered under the War Resolutions Act. And the second part of my broader inquiry would be, the U.S. has not declared war since World War II. So as an intellectual or legal matter, how do the U.S. administrations and its legal counsels justify undertaking such massive international military acts without what some would consider due process?
Okay, thank you. Why don't we collect 2 or 3 questions, if that's all right? So we have a kind of question on the War Powers Resolution and on hostilities up to the present moment. Other questions? Yes, please.
Can you talk about some of the challenges of having not just the president as your client, but also the senior staff as your client, and also the challenges associated with not just being a counsel, but also being manager in office of staff employees?
Okay, and one more question. We'll kind of bundle them together. Yes, please.
I was curious how the White House counsel's office deals with congressional investigation, how they represent the president, the choices that are made in that direction.
Mr. Doher, did you want to pile on as well? We'll take a fourth.
Yeah, sure. You mentioned earlier the signing statements, and I was curious how your office tackled that, given the previous administration's kind of using that more and more as a card with debt. And if you disagreed with its standing, now once the precedent's already been set, do you still use it? Is that more of an LLC thing, since it's more about the institution of the executive branch, or is that your office?
Okay, Bob, you want to kick us off with the WPR question?
Yeah, well, that's a huge, huge issue. I mean, it's a huge question, and I would eat up maybe a couple of days answering it. So let me just give you a few short strokes, and I think part of it, I think, of your conversation is very much implicated in the discussion recently about the draft AUMF authorization for the use of military force that the administration proposed for the ISIS situation. We have a structure, and you implied that in your question, we have a structure for making these decisions that has become very complicated, as you well know. And it is a very complicated relationship between the executive and the congressional branch. The War Powers Resolution, for example, if you look at the opinions that have construed the War Powers Resolution over a series of years, is in desperate need of updating. However, there's no consensus about how that's going to be approached, including on the congressional side. And so there's just a constant tug of war and the arrival in each instance of something like an accommodation between the Congress and the executive branch. It's not as a doctrinal matter or as a matter of a formal framework an intellectually satisfying situation. It's a very difficult situation. But I do think, as demonstrated by the president's proposal here, of this new AUMF draft, that this administration, just as it did, for example, in the case of Syria, as you recall, has definitely tried to force a dialogue with the Congress. And it has to be a dialogue between the Congress because it's a discussion about the allocation of constitutional responsibilities. And the president is right now engaged with Congress in that conversation. And as you know, absent that authorization, the president wasn't prepared to take action in Syria. So the answer is, from administration to administration, the view of the responsibility of the executive to take that kind of action, to force that sort of dialogue with the Congress has varied. In this administration, I think it's clear the president believes there needs to be that conversation, and the executive has initiated it. And that's a critical first step. I mean, that's just the critical first step. If there's no respect for that discussion between the coordinated branches, then it's an even more unsatisfactory situation. But here, at least, we have a situation with very tattered law and a lot of unsatisfactory precedent and a lot of confusion around the core principles, where the executive is making an effort to put the Congress in a position where a productive dialogue can occur. It's inviting it, and it's entering into it willingly.
Thank you.
Kathy, turning to you on the question of interacting with staff about managing 45 lawyers. So you're a big boss of a non-trivial law firm, and maybe also, since I know you did a lot of this in your role as White House counsel, fending off investigations or handling and managing investigations from the People's Branch.
Yeah, okay, so I think mine doesn't work. One of you. Okay. There we go. It's interesting. It's a challenge sometimes dealing with the president's staff as your clients and how that relates to the president, because sometimes the staff has done something that isn't necessarily in the president's interest or turns out not to be in the president's interest. And so I think you always have to be mindful. You hope that doesn't happen very often. But I guess an example, not from our administration, but from the prior administration, would be, Scooter Libby. So there was a circumstance in which there were, people who clearly, Scooter Libby, if you believe the facts as the government alleged them, he was acting on behalf of the White House, certainly not in his own self-interest, but what he believed to be in the interests of the White House and the president in, discussing classified covert matters with others. But when that became public, it was no longer consistent with the White House's interests, because the President Bush had to politically, and I think just, frankly, there was no other way to sustain it. He had to say that if anyone here actually engaged or is discovered to have engaged in inappropriately disclosing classified information, then they're going to be immediately fired, and I'm requiring everybody to cooperate with the investigation. So that's a situation where you have to make very clear to the staff, and most of them are sophisticated and they understand, but that even though you might be giving them advice that if at any given point the interests of the individual staff member and the president diverge, that the president is your client, and the institution is really your client and not the individual. On the management side, we had the way that the office was structured under both Bob and me, and we really together set this up in anticipation of the Republicans taking the House in 2010, is that we sort of had, I would say, one side of the office that was the defensive practice and one side of the office that was the offensive practice. So they were working on policy, and a lot of the other functions of the office, judicial nominations, vetting executive branch nominees, ethics, those types of things. And then we had another whole team in the office, and all they really did was defense, respond to congressional investigations, handle, to the extent that there were criminal investigations to which we had to provide information, and there were a couple, that they would sort of manage that, with the idea being that you don't want to have a congressional investigation sort of incapacitate the White House as the president's trying to march forward with his affirmative agenda. And so you have kind of a special team of experts who are working on those types of issues. And, I think we found that was a very sort of functional way to do it. And there's a real expertise that develops in congressional investigations. It is very much a give and take process. How much the executive branch has to give is sort of directly related to how much public attention is being brought to bear on the particular matter that's being investigated. And so, the legal issues there too are all wrapped up in the sort of political issues and the communications issues.
Bob, you want to take us to the question of signing statements, and this will be our kind of last moment. So if you're getting antsy, I hear you, I feel you. Bear with us. This might be the thing that you learn in law school that changes your career. Bob, no pressure, okay?
No, you're safe. You're safe.
But maybe kind of we could generalize to this kind of larger, using signing statements as a way into this larger question of the presidency. It's become so important, seemingly ever more so, regardless of the political party of the occupant of the Oval Office. It's just come to dominate our public life, and I guess signing statements are something like a kind of metaphor for all that the presidency has come to mean and the power of the president as a lawmaker, not to say someone who executes and enforces the law. So, I mean, does that capture something true? Does this signing statement issue capture something authentic about where the country has gone?
Well, first of all, I mean, there's a lot to be said about the presidency and an institution, whoever occupies it, and in many respects, I call it the impossible institution, and it's in so many respects. Again, irrespective of occupancy, it deserves and obviously receives a great deal of attention just in those terms. As for signing statements, here is the question again of whether or not a particular action of the presidency to protect its authority, the presidency, the action of if a president to protect his or her authority is exercised with appropriate restraint and in good faith, keeping in mind the responsibility to superintend the office, to have a constitutional vision of the office, and to guard against abuse. And as you know, there were significant criticisms of prior administrations for signing statements that, a signing statement policy, if you will, that was thought to transgress constitutional boundaries, to illustrate a lack of self-restraint, a lack of respect for shared constitutional responsibility. And the Obama administration operates under a set of policies, if you will, toward signing statements that was designed to address those concerns with abuses, and to have signing statements that reflected what people were most concerned about. That is to say, the declaration that a particular congressional enactment was not binding for constitutional reasons, and the executive, for all intents and purposes, was going to disregard it or construe it differently than Congress might have wished to have had it construed. That was going to be done in very carefully delimited circumstances, in good faith, with care not to transgress against constitutional boundaries. And I think that's what you increasingly need presidents to illustrate, whether it's the abuses of the Nixon administration, pick your administration, where there's been a controversy about the capacity for constitutional self-restraint, given that so many other safeguards are inadequate or have fallen away. The presidents have to be pressured on that point, and something like signing statements and the policy towards signing statements is part of what presidents have to offer in the way of accountability on that issue.
Okay, I lied. One very last question to both of you. I can't resist, which is you have a room full of students, many of whom are going to launch careers in law, policy, public life. So what's the best bit of professional advice you would dispense to a 1L, a 2L, a 3L who is minded to follow in your footsteps and head to Washington or a state capitol or some city government and to become immersed in law practice at the intersection of public policy and politics?
Do what you love. Don't worry about what other people think about what you're doing. Be willing to take some risks and do the job that you're doing really well. Don't be thinking about the next job while you're doing the job that you're doing. But most importantly, don't do a job because it's what's expected or because it's what's prestigious. Do what you really feel passionate about doing, and success will follow from that.
And I would say, for people who know that that's what they're interested in, don't delay. One of the things that I have seen happen is that people come out of law school and they say, boy, this is what I really want to do. Somebody says, well, you know what, you're going to really benefit, certainly at the salary levels, but also for your professional training if you spent the next 4 years doing mergers and acquisitions at, you know, greed, wherever it happens to be. And they say, okay, that sounds like good, yeah, really good professional training, that's what I'll do, and that's the last everybody's ever heard of them. You know, they'll spend 6 or 7 years doing that, and they're locked into it, and then it's harder for them to break out of it. You know, if you want to be a lawyer in public service, first of all, I don't think it's true that you can never trace back to private sector practice if that's what you want to do in some form, even if it's not large firm practice. If that's what you want to do, go out and do it now. You're young, you have energy, you're needed, do it now. It's institutions like this need to generate students not 10 years from now who are involved in public service, but who are involved in public service in whatever form that you choose soon. You know, coming right out of law school when, you know, you're fresh and ready to take that challenge on, and you're not burdened by prior decisions that you've made that just make it that much harder for you to have that flexibility.
Please join me in thanking Kathy and Bob.